My name is James DeCristofaro, real estate attorney, New York. This is video number 4 in my 5-part video series about residential real estate transactions in New York City. It's called this. The title of this video is There's an Offer and Acceptance on a Home in New York City, Now What? So in this video, we're going to cover two things. What happens at the signing of the contract? And the second thing is what happens after the signing of the contract but before the closing. So that time period that's between the signing of the contract and the closing. First, again, signing of the contract. Second, what happens after the signing of the contract during the period between the signing of the contract and the closing. And then in the next video, video number 5, we're going to cover what happens at the closing. So you may know this, you may not, but in residential real estate transactions, there are non-attorney states and there are attorney states. What's the difference? Well, in non-attorney states, attorneys are not involved in residential real estate transactions for the most part. There are always exceptions. This is just the generality. And typically in non-attorney states, the person or the entity that drives the purchase and sale, well, there's two. Buyers and sellers agent. The agents typically do a wonderful job and they bring the transaction together. And then at the closing, there's the title company that does everything. In New York, it's a completely different story. While the agents are certainly involved, the animal is very, very different. There are loads of attorneys involved. The seller has an attorney, the buyer has an attorney, the bank has an attorney, the co-op has an attorney. There may be another attorney involved or two. And we've got the title company, we've got the agents. There's a lot of parties involved. And the title company typically is not represented by an attorney. They're represented by a title closer. And these title companies, they do loads and loads and loads and loads and loads and loads of these transactions. They're very good. They know what they're doing. I've only had great experiences with title companies, and they are definitely instrumental to the process at the end. So at the signing of the contract, it's pretty simple. But before that, let's get to the preparation of the contract first, right? You can't sign it unless it's prepared. And typically in New York, the seller's attorney prepares the contract. Usually the base contract is a form, and one that it's prepared by experts. Title companies have them. It's the base document. They're basically the same. Well, they're very, very, very similar. They have different provisions in there. The one that I recently used, this is who it says it was created by, jointly prepared by the Real Property Section of the New York State Bar Association, the New York State Land Title Association, and the Committee on Real Property Law of the Association of the Bar of the City of New York, and the Committee on Real Property Law of New York County Lawyers Association. So those are 4 or 5 entities, and each of those entities has a bunch of real estate experts on it. You can rest assured that the base contract is going to be pretty complete or pretty well on its way out of the gate. So while we all know that nobody's perfect, including all 5 of those entities and all 5 of those entities professionals that help prepare the document, there are variations, and those variations are represented in what we call riders. So the seller prepares the base contract, enters the address, the names of the parties, and whatever other identifying information in there, either crosses out the financing contingency or leaves it in, and then adds riders. There are standard riders that we've developed over time, and then there are specific riders that we include for this particular sale as we understand it. Well, as the seller's attorney then takes it and emails it to the buyer's attorney. The buyer's attorney reviews it, makes his or her own additions or subtractions, modifications, edits, whatever it is, usually adds several riders, sends it back. It goes back and forth, not a lot. Usually it's once over and then once back. Once the buyer and seller agree on the appropriate language, on the appropriate timeframes, on the appropriate riders, they have their respective clients sign it, and the buyer leaves a security deposit with the seller's attorney, and it's put into an escrow account. Typically it's 10% in residential real estate transactions. Then once that happens, guess what? You're in contract. And so again, so that's what happens at the signing of the contract. That covers the preparation of the contract and the signing of the contract. The second part of this video is what happens between now, which is at the time of the signing of the contract or after the signing of the contract, and the closing. In this time frame of the deal, after the contract but before closing, the buyer then rolls up his sleeves and does its diligence. It formally applies for the loan, although it may have a pre-qualification letter. Now it provides the contract to the bank or the lender and whatever other documents that the lender requires, and they formally start that process. The buyer's attorney orders a title report for the most part to make sure that title is okay. This is with the exception of a co-op. A co-op doesn't, you don't really review a title in the purchase, a title report in the context of a co-op purchase, because you own shares or you're buying shares. You're not buying the real property itself. So there are other considerations to look at, and those are the minutes and what's happened over time, what's happened at the meetings, and the buyer's attorney, if they know what they're doing, and they should, orders the minutes and whatever other documentation that the co-op has with respect to that unit. There are other things that the buyers do, such as an appraisal if there's a loan, and if it's a freestanding home, a buyer would order a home inspection to see, make sure that everything is working properly from, the ground up, including the water, the appliances, the structural integrity of the building, the functionality of the windows, energy efficiency, you name it with respect to the inspection, and it can be covered. If there are no issues, closing gets scheduled. If there are issues, a couple of things can happen. Number one, the seller typically could have 60 days to fix them, and if it does, then, and it's to the satisfaction of the buyer or should be reasonably satisfactory, then it goes to closing. If the seller doesn't want to fix them, there could be an adjustment to the purchase price. For instance, 5 windows should be replaced. The seller's like, I don't want to do it. I'll give you a credit for $10,000. Then, and if the buyer agrees, then great, we schedule a closing. What isn't good for the progress of the deal is if there are irreconcilable issues or issues that the buyer and seller don't agree on fixing or a path forward to fixing, and then there's a fight typically, or there can be a fight over who gets the security deposit back, or can the buyer compel specific performance. In other words, can the buyer make the seller sell the property to the buyer? And New York is a state where if there's an enforceable contract and the seller defaults, the buyer can force the seller to sell the property to the buyer. Again, that's called specific performance. So if it goes forward, let's assume it goes forward, we schedule the closing. And that's what we cover in our next video.
I would definitely recommend Lawyer James.
It changed my life.
James has done an outstanding job.
But he kept me calm, kept me on point.
I would definitely encourage you to get in touch with James as soon as possible. As a matter of fact, do it now.